multiple things can be true at once. And I think we're watching a case of one, a very overzealous lawyer who has claims, and two, a very unhinged public figure who has a documented history of problematic behavior. Hi, everyone. How are y'all? Happy Tuesday. It's the second Tuesday in a row that we're here doing a live stream. Let me go ahead and get the agenda pulled up. I figured a good place to start would be what I said last time, which is encouraging people to find the gray and the nuance, because the law is about the gray. Because I find that people are either have preconceived notions about what the law says, or they have decided, based on the court of public opinion. So sometimes, unfortunately, the truth is uncomfortable, and sometimes there are inconsistencies. So we are going to talk about that. All right. And then hopefully that played with good audio. Sometimes when you play something from YouTube and it's not embedded, then it acts a little weird with the echo, but hopefully the audio is fine, and then the audio should be fine now. All right. Wonderful. I'm glad you got a notification. All right. So this is going to be what we are discussing in our Jay-Z lawsuit follow-up. To know, not much has actually changed on the legal front, and we're going to get into the case docket as well. I pulled it up earlier today, and then I pulled it up again at 5:06 p.m. So unless anybody is submitting some late filings to SDNY, there shouldn't be anything new besides what we are discussing right now. However, there was an interview given by the alleged victim earlier this week. Today's Tuesday, I believe it was over the weekend, and then that spurred a lot of conversation because there were inconsistencies, as well as that did trigger one additional filing. So we're going to talk about that. But for any of this to make sense, we are going to start with a little bit of Civ Pro, which Civ Pro is civil procedure. A little Civ Pro lesson. So this is for all the law students, really. We're going to discuss the hurdles of Rule 12b1 and the rule. Oh, I have this spelled twice in here. That's what happens when you are writing things fast. Hold on, let me fix it in real time. Okay. Should be fixed. Okay. And then Rule 12b6, which those are two different motion to dismiss rules under FRCP, the Federal Rules of Civil Procedure, which I haven't thought about Civ Pro in that class in a very long time. However, that's what we're going to focus on today, because we have various media outlets saying this case is likely to be dismissed, that acting as if there is a new MTD, new motion to dismiss. However, according to the case docket, there is not a new motion to dismiss. They are just going off of the former motion to dismiss, which we talked about last week. So we're going to get into why it would appear to be new, but it's not new. And a little bit of Civ Pro history, which is Ashcroft v. Iqbal and the plausibility standard. Then we're going to discuss the interview and the inconsistencies and why, unfortunately, in real life, you are not going to find a perfect victim. And there are various cases that show that, and why that the inconsistencies don't necessarily denote that the underlying claim is untrue. So we're going to talk about that and the totality of that. And then the very brief motion to dismiss, which we discussed last week, more so the motion that Jay-Z and his team from Quinn Emanuel, they filed a motion for the alleged victim, for her to be publicly named and to not allow her to proceed anonymously. And inside of that filing, there was a very small motion to dismiss under 12b1. So we're going to talk about that. And then where the case is now and what may happen. So I'm sure you all know, if you are familiar with this channel, or if you are familiar with the legal system at all, the legal system is slow. It is very unlikely that the judge rule on the motion to dismiss before Christmas. Christmas is next week. However, since people asked for an update, I figured we'd do this update. So that way, at least the legal procedures, people would have a better understanding of. All right. And I realized, because I was worried about whether or not the clip would play right, I didn't even do my intro. Hi, welcome to my channel. Allegedly Stephanie. It's me, allegedly. Recovering lawyer and someone who, had a brief stint in entertainment law and then mostly in tech. All right. Okay, so let's get into it. And first, a huge shout out to Patreon. We are going to have a Patreon video live stream tomorrow. And an extra thank you to my Sanseer tier patrons, Allison W., Ed Guy, Juanita, Judy, and Robert. I appreciate y'all. And tomorrow, you can join Justin from King of Reads and I to discuss, I would say, in the most cynical and jovial way, 2025 planning, how to survive Fascism 3.0, and capitalism, and just general musings to wrap up the year. So if you want to catch Justin and I cackling, we will be on Patreon tomorrow at 5 p.m., which, knowing us, probably 5:15. All right. So let's get into our little civil procedure mini lesson. So the probability standard and rule 12b6. This will make sense because there's no point of reading a lawsuit and going through a lawsuit without understanding what the actual law is and what either the defendant or the plaintiff are essentially, and their lawyers are essentially moving to do. So we are going to start with a little background of the law, and I will try to make it as interesting as possible. Shout out to Professor Salahi, who, a decade ago was my Civ Pro professor, and it became one of my favorite classes, which is odd and ironic because the class is very dry. And because he was such a lovely person, he received feedback as a professor that he was a bit monotone and the class is already dry. You're talking about rules of how to do a motion to dismiss. It's literally civil procedure. How do you, when you are filing a civil lawsuit, what are all the court rules? It's not the most exciting thing. So when he received that feedback that he was a little monotone, it must have been 2 years before I took his class, he decided that he would then raise his volume. So in an effort to wake people up, he would start off like this and then all of a sudden get really loud. And then he was a very mild-mannered, nice man. But because of that way of teaching, I remember a lot of this very well. And I was surprised that I remembered all of this. All right. So we're going to have to go back to what is objectively a very sad case, Ashcroft v. Iqbal. So the primary holding in Ashcroft v. Iqbal is when considering a motion to dismiss for failing to state a claim, a court should accept the facts pleaded in the complaint as true, unless facts merely restate legal conclusions. So essentially, for all of the people, when you see there's a motion to dismiss, this is getting dismissed automatically, that is not the legal standard. The legal standard is if you enter something into the federal court, the court has to take your facts as true. They are not supposed to be finding issues of fact under 12b6. Under 12b1, you have a very different legal standard. However, they're intertwined, so it's easier to start with 12b6. Interestingly enough, because a lot of people are like, oh, well, Attorney Spiro, who is the attorney from Quinn Emanuel, and he is representing Jay-Z. He is, I would say, probably the lead partner on the case, and he's the one been doing all of the press, which we'll talk about the press and distancing himself from Diddy, despite the fact that we have spent numerous years seeing all these pictures. In a second, he basically has stated this case is getting thrown out and people are taking that as fact when the legal standard is not so, even. Not y'all telling me probably 5:15 or 5:30 for tomorrow. Listen, we were on time-ish today, sort of, kind of, maybe. All right. So with that, anything stated, as long as it's plausible, it's a plausibility standard, is what gets taken by the court. So when you, for example, if I were to sue in federal court and I made this wild conspiracy theory, as much as I'm disgruntled with the student loans, and I stated, oh, you know what, the student loans are specifically designed to attack me personally because I was the first in my family to go to law school, and the student loan system designed by Joseph Robinette Biden is personally designed to charge me literally $85,000 in interest, which it did. And I feel personally attacked and I'm filing for intentional infliction of emotional distress, etc., etc. The plausibility that Joseph Robinette Biden designed our student loan system, which he didn't, our interest rates are set by Congress. The plausibility of that is likely implausible. If I were to go to SDNY, Southern District of New York, and file that in court today, they would say, young woman, I know that is very unfortunate. It is unfair. It is predatory, but these set of facts are not plausible. Joseph does not care about you to design a student loan system to trap you specifically. So that is essentially what the plausibility standard is in Rule 12b6. So the underlying case, if you were curious about Ashcroft v. Iqbal, essentially in the underlying case, and unfortunately, there was a man whose last name was Iqbal. He was Muslim American. After 2001, the federal government designed various programs that were inherently discriminatory that went after various Muslim communities throughout the United States, as well as targeted young, middle-aged, and older Muslim men. He unfortunately was subjected to, according to him, and it is a fact, was sentenced to prison. He didn't do anything. Strip search, all these awful things happened to him. He then decided to sue not only his jailers, but he sued the federal government, and he specifically sued the AG, the attorney general at the time, who was Ashcroft, under, hey, you use this discriminatory policy and this discriminatory practice to personally go against me because I am a Muslim man. While those set of facts were never in question, and they were believed to be true, and he had proven them to be true, because he wanted to sue the attorney general in his personal capacity, the attorney general and their team decided, oh, well, we have qualified immunity. And under qualified immunity, you cannot sue certain states or federal workers, such as the police abuse qualified immunity all the time. And the attorney general essentially said, you can't sue me under qualified immunity. I was just doing my job. I wasn't trying to target you, even though the attorney general and the head of the FBI at the time was also named in the suit. They were specifically targeting Muslim men. Ashcroft v. Iqbal is a very sad case. It was a 5-4 decision by the Supreme Court, in which the Supreme Court decided, you know what, even if we took all of these facts as true, these statements are just legal conclusions. These statements that he's making in his pleadings are legal conclusions of, I've been discriminated against, so therefore that is a violation of my constitutional rights as an American citizen. And though they were not basically arguing facts of law. And so the standard was then put into place that the court under 12b-6 to pass a 12b-6 motion, they are not designed to resolve issue of facts. However, you cannot just reassert issue of law. So if we apply that to the case that we're talking about now, what do we have? We have issues of facts. Under 12b-6, the law understands and states, okay, we're just going to take everything the plaintiff says as true, and then during discovery, we will argue about issue of facts. Now, one of the things that is going to come up during this motion to dismiss, however, is 12b-1. Rule 12b-1 is a much lower standard than Rule 12b-6. All right, so I say all that to say, I think I went through it pretty quickly. I'm proud of myself, pretty succinctly. So that way, that legal basis is there, and then we can talk about it in a second after we talk about this interview and the inconsistencies. Okay, so I wanted to know the exact date. I believe this was on the 13th. I believe this was on Friday that this interview came out. So the alleged victim in this lawsuit against Jay-Z and the other Sean Combs came forward to NBC News. She did an interview, which she remained anonymous, and she acknowledged that there were some inconsistencies in her story. NBC News also then did an investigative report to which they found that some of the things she said were inconsistent. However, she maintained that the overall harm that she's claiming was true. So we're going to read some of the report. All right. But the woman and her lawyers also acknowledged that there were some inconsistencies in her account in response to questions from NBC News. And quote, I have made some mistakes. In recollections of that night, the woman identified as Jane Doe in the lawsuit filed against Jay-Z and Diddy told NBC News. The woman said she stands by her allegations overall. The inconsistencies in her account of the incident alleged to have happened 24 years ago do not necessarily mean the allegations are false. And again, this is from NBC News. So before I give you all my opinion, so that way we know from the same basis where we're talking about. Among the inconsistencies, the woman said her father picked her up after the alleged sexual assault, but he says he doesn't recall that. The woman also claims she spoke to a celebrity at the after party where she said she was assaulted, but that celebrity said he was not in New York at that time. And images from the evening show Jay-Z, whose real name is Sean Carter, and Sean Diddy Combs at a different location than the one the woman described, although their whereabouts for the entire evening are unclear. Okay. Do we want to get to what he said yet? Let's see. Okay, before we get to how Jay-Z responded to this, one of the things that does not exist in the law is a perfect victim. So she is maintaining, okay, it's been 24 years. I have made some mistakes in what I'm saying. However, the assault, she is maintaining that it is the truth. One, there are a lot of very high profile cases in which the actual victim was found to have lied at one point, or has found to been lied by omission, where they just omit the truth, or they've just simply forgotten, depending on the numbers of years. It does not mean the underlying harm didn't happen. A prime, and I would say controversial example of this is in New York. We used to have, and hopefully it doesn't come back, Eric Adams is trying to bring it back because he is a scourge upon New York. We used to have stop and frisk. Stop and frisk was an extremely racist policy to which the NYPD was accosting and harassing young Black men and young Hispanic men at record rates, over 80%, where they would just literally stop and frisk you under the assumption that, oh, well, you're doing something wrong. Stop and frisk was banned under SDNY. The case went up through the courts. Partially, the plaintiff in the stop and frisk case to ban stop and frisk was found to have an assault rifle on them. However, their lawyer argued, okay, they had an assault rifle on them. They shouldn't have an assault rifle on them. It's obviously illegal. However, you only stopped the young man in question because he was, I believe it was actually a young Hispanic man at the time. I can't remember right now, because he was Hispanic. They won that case, and that's why we don't have stop and frisk anymore. He wasn't a perfect victim. Honestly, he was clearly doing a crime, but that did not take away from the fact the underlying law was being abused, because stop and frisk is a racist law, which is why we don't need it. Just your skin color doesn't denote whether or not you're doing something wrong. So while I know people want to have a perfect victim, you cannot have a perfect victim. And while sometimes it's hard for people to live in the nuance, it doesn't necessarily negate all the other things that she has alleged. Now, in response to this interview and these inconsistencies by the alleged victim, Jay-Z then gave a statement to NBC to which he said, "This incident didn't happen, and yet he filed it in court and doubled down in the press. True justice is coming. We fight from victory, not for victory." I have no idea of what "we fight from victory, not for victory" means. Again, my question is, why doesn't he just let his PR team handle it? Because every time he decides to make a statement, it just gets worse and worse. And then I just have more questions, because it's giving some type of, Hotep alliteration of "we fight from victory, not from victory, but for victory." All right. The other, and I would say the more, oh gosh. This is a very hard case. The perfect victim in France who had a husband drug and traffic her and their children is still fighting for justice. Perfect doesn't save victims. Exactly. That case is awful. Awful. If you have, I do recommend taking a deep breath and then reading the case. But if you want to see the utter depravity of some people and why it is so important to fight for victims' rights, even if you feel uncomfortable with the way that they conduct themselves or etc., the underlying issue remains. All right. Let us get into what I think is more important, in my opinion, which is this. So Busby says he is continuing to vet her claims. Jane Doe's case was referenced to our firm by another who vetted it prior to sending it to us. This is what attorney Busby told NBC News in an email. Our client remains fiercely adamant that what she has stated is true to the best of her memory. We will continue to vet her claims and collect corroborating data to the extent it exists. Because we have interrogated her intensely, she has even agreed to submit a polygraph. I've never had a client suggest that before. In any event, he added, we always do our best to vet each claim made, just as we did in this case. This has been extremely distressing for her to the point she has experienced seizures and had to seek medical treatment due to stress. I think this part is important for multiple reasons. One, as a lawyer, I don't know why he will say that. Two, it does come off objectively as deflecting blame, as well, I didn't find her, even though he, and I already said this last time, crassly put out that call line. In a way, he slightly threw her under the bus while still shielding her and still saying, well, I believe it, but yes, if this goes awfully, I did not find her. And that is going to now be used and is being used in the current filing by Quinn Emanuel and attorney Spiro, basically stating, well, he doesn't believe in her claims, even though that's not what he said. All right, let me read through some of these comments. No, I never did litigation. And the reason why I didn't do litigation is because I interned a whole semester at SDNY, which is very prestigious to have a judicial clerkship. And it wasn't for me. It wasn't for me for multiple reasons. I think I've done a video on this. I think there's a video. When you work in the court system, particularly if you do federal district court and you do federal court is much more prestigious, much more, the heights of power, etc. The way they treat certain perpetrators and certain alleged perpetrators will really piss you off, particularly as a Black person. The way you see the stark differences. So it was not for me. All right. I think it's interesting that a lot of people are asking what's wrong with him defending himself. This is somebody who's been accused of multiple things and never says anything, has their PR team always say something, and all of a sudden now is speaking out in a way that is not only detrimental to themselves, it doesn't make any logical sense. There's no point of paying what is one of the most expensive legal firms in the world, as well as having extremely expensive PR team to then undermine that by making like offhand comments. It doesn't come across as cohesive either. And it then questions the veracity of all of the statements because none of the statements actually make sense. All right, so which brings us to the legal standard to survive a Rule 12B motion to dismiss does not require a perfect victim, which we just talked about. And we talked about this already too. We're going to do specifically the legal update since the last live stream, which was on 12/10. All right, because people asked for, in the last video, they wanted an update. I think sometimes we forget that the court moves slower than molasses. So specifically, the court, we had a live stream on 12/10. If you look, let me move me so you can see a little bit better. If you look at the screen, this is the case docket from today. I double checked it again at 5:06 p.m. So unless there's any late night filings, this has not changed. The only two things that have been issued after the time that we did the last live stream, which was December 12th and then December 13th, we have a summons issued and then a motion for the conference. So let's see what those are. Spoiler alert, they're not that interesting. But this is the first one. I cannot see, so I have to lean in. The only thing interesting about this summons is, hey, a lawsuit has been filed against you, etc. And you have to list out all the defendants' names and addresses. Of course, these are not the actual addresses. These are their places of business usually. And then sometimes the defendants, if they have public addresses, they'll use the public address as well. The only thing interesting about this summons is Sean Combs, since he is the main person being sued here. They're both being sued, but you'll see here all of Diddy's business as well. Diddy's address is listed as the Metropolitan Detention Center. And that level of pettiness is the only thing interesting about what was filed on 12/12. All right. And then what was filed on 12/13 is basically a recitation of what we just read from NBC. So you have Quinn Emanuel filed this to Judge Torres, which essentially they are requesting a hearing to go over the motion to dismiss, which the motion to dismiss was filed last week on the 9th. So we write the court on behalf of our client, Sean Carter, on a matter of extraordinary and grave importance for the integrity of the proceedings in the above mentioned case. Today at 7:27 p.m. EST, on the 13th, NBC News reported an interview that the reporter conducted with the anonymous plaintiff in this case. The interview outs plaintiff's allegations for what they are, a sham. And then essentially the rest of the letter then references the NBC interview, but through the light that is more favorable to Sean Carter, not Combs. Both of them having the name Sean is very back and forth now. All right, so there's no point to really read it, but that's what you have here. So that's why they have it as the superscript, the reference, like, hey, we are referencing this to say we would like the judge to now hear our motion to dismiss, speed this up, let's go. Other than that, nothing else has been filed. Now, the interesting thing that is happening, though, is because the court is extremely slow and because the court moves at its own pace, now you see Jay-Z's team also working with the court of public opinion to then, I would say, distance him from Sean Combs, Diddy, which we have a video of that I'm going to play, and then also to essentially add as if they have filed a separate motion to dismiss, as if NBC has dropped some type of bombshell. And that's not necessarily what the legal documents are showing. Because as you can see, the legal documents are just showing they're paraphrasing what NBC already said, and then there's no new actual motion. So Rule 12b1 on paper and zealous advocacy in the court of public opinion. All right, so this is the same motion that we discussed last week. However, we are going to look at a different 4 paragraphs in this motion. So defendant Sean Carter's motion to deny plaintiff's request to proceed anonymously pursuant to Federal Civil Rules of Procedure 10A or to dismiss complaint pursuant to Rule 12b1. Important to note that it's either or. They either want her to publicly be named as the petitioner in this lawsuit, or they want it dismissed. Okay, and then you can see here, which is why last time we focused the majority of that live stream, not on the motion to dismiss, but on their desire to have her named and that she should not be allowed to operate anonymously. As you can see here, it's about a page. It's really 4 paragraphs dedicated to the motion to dismiss. However, if you were to pick up a newspaper, do people read newspaper anymore? We need to bring back the newspaper, actually. We need to bring back real journalism. But anyways, if you were to click online now, all the headlines on now are on the motion to dismiss, but the motion to dismiss, again, was filed previously on the 9th. Now, what is Rule 12b1? Rule 12b1 is lack of subject matter jurisdiction. Okay, this is from the filing from the 9th. It's basically just saying, hey, we need to dismiss this under Rule 12b1. As detailed above, plaintiff's motion fails to meet the stringent requirements for the narrow exception to the rules. Numerous courts have rejected similarly vague and unsupported assertions at the pleading stage. Plaintiff has provided no evidence, no affidavit, declaration, or specific factual support to establish the kind of severe harm necessary to justify pseudonymity. Her vague assertion of potential harms falls short of the stringent requirements established for the Second Circuit and other federal courts. Even in the sections calling for the motion to dismiss, they're not actually focused on dismissing the case. They're focused on bringing her identity to the public. Okay, and then there were 2 more paragraphs, and that's it. There's only 4 paragraphs dedicated to actually getting the case dismissed. Moreover, plaintiff's failure to comply with Rule 10A, again, Rule 10A has to do with being anonymous, has nothing to do with dismissing the case, deprives the court of subject matter jurisdiction. Federal courts lack jurisdiction over unnamed parties because such cases are not properly commenced. This is partially true. However, back to what I said last time, the other petitioners and the alleged victims that have sued in similar manners, they started anonymous, and then after these documents, similar documents were filed, the judges in those various cases then ruled like, okay, you need to identify yourself, you need to state your name. Every single one of them decided, okay, I'm keeping my case and here's my name. That is likely what's going to happen in this case as well. Unless she drops the case is likely not going to go anywhere. Plaintiff makes no effort to explain how litigation will work in practice without Mr. Carter knowing who plaintiff is. Again, this has nothing to do with dismissing the case, even though the section states, okay, we want to dismiss the case. This has to do with whether or not they can identify the plaintiff. Accordingly, because plaintiff fails to meet the requirements for pseudonymity, Lord, that word, sorry, has not properly connected this action, the court should deny her motion and dismiss the amended complaint per Rule 12b1. The way for Spiro is for Jay-Z, and Busby is for the alleged victim. The way for Busby and the alleged victim to get over this hurdle and this request is going to be identifying the alleged victim. All right. Now, on top of that, you now have Jay-Z's legal team, which Spiro is a partner at Quinn Emanuel, so they have him he's usually, I would say, like the named, is it playing properly? No, it's not. Hold on, sorry. He is usually tasked with PR and the legal component, but then you probably have associate attorneys who are doing the drafting. Share this tab instead. Here we go. Okay. Can y'all see it? Let me make it big.
How's Mr. Cobb feeling?
No, we don't need to.
He's upset. Real victims from coming forward.
Right. Will Mr. Carter say anything more specifically about Mr. Combs? He didn't really address him in his statement, but anything since outlets and internet speculation have tried to affiliate the two of them, he didn't really in his statement specifically say anything about anything else.
The audio is a little.
Mr. Carter has nothing to do with Mr. Combs' case or Mr. Combs. They knew each other professionally for a number of years, just like in all professions. People know each other. At the music awards, they support each other. If you go to the NBA All-Star game, they support each other. That's just how professions work. There is no closer association between any of them. That's also a matter of fiction. That's all that there is. He doesn't know anything about the charges or allegations against him. He has nothing to do with that case. And there's nothing more to say.
Long before they became...
Yeah, I'm not buying that. Anybody who's been alive in the past 30 years knows there is plenty of evidence to state and to show that they are indeed good friends. Interestingly enough, the internet has been trying to drum up fake businesses between the two of them and say, well, these are two moguls. They have businesses. What? They have no businesses together. They have no businesses together. They are simply friends. And I do think it's interesting wanting to distance yourself from somebody who has, for the better part of a year, been accused of very heinous things. Not when they got accused, not when a tape came out showing that they are indeed an awful, vile person, but when you are now getting roped into it, now you want to distance yourself. There are enough pictures. There are enough birthday parties. There's Diddy's 50th birthday party. These men are all similar ages, 56, 55, around there. There's enough to show that for many, many years, you have decided to stay friends with this person. Next thing, he's going to have Spiro telling us that, oh, R. Kelly was not his friend and they didn't do 2 albums and a tour together. We are not that silly. I would hope not. Okay. Where do I have this in here? Let me see. Okay, so a little bit of legal background, just so, for more civil procedure, since that's the only thing really to focus on here, is civil procedure. For Rule 12b1 rarely gets discussed because usually defendants use Rule 12b6 to state, hey, you don't have a claim, and this claim is implausible, so let's use Rule 12b6 because 12b6 deals with whether or not the facts are plausible. That is not what Quinn Emanuel and Spiro are claiming. They're not using 12b6 because under 12b6, they would lose that motion. They're using 12b1. 12b1 is a lower standard. And I will say, going through and rereading all of it, this is much better lawyering than the original extortion lawsuit they filed, which seems in hindsight, maybe it was very hastily written. This makes sense from a defendant's perspective to have your law firm claim this because 12b1 is a much easier standard. Do I think they'll win under this standard? I think it depends on the judge. I'd be very curious to see. It would set a precedent that you can't have people that have inconsistencies, which the court generally tries not to set those types of precedents because there are multiple people that have inconsistencies on a regular basis. However, just so, we have the same set of civil procedure to go from, here we are. So essentially 12b1 goes with 12b6. So 12b6 is this plausible on its face? So determine whether the remaining well-pleaded factual allegations plausibly give rise to an entitlement of relief. Is it plausible that after the VMAs in 2000 that a young girl attended an after party and was assaulted? It is plausible, unfortunately. All right. And then you have the 12b1 standard, which permits a defendant to move to dismiss a claim for lack of subject matter jurisdiction. The presumption against subject matter jurisdiction works in favor of has the burden of demonstrating subject matter jurisdiction. The applicable standards favor the defendant even more if the defendant makes a factual challenge, which, as we see, Attorney Spiro is making a factual challenge to the facts. Because under 12b1, you can pull up the facts and state, well, there's inconsistencies. I don't agree with this facts. I don't think that this makes sense. So specifically, the elements that you have to prove, a court may in its disposition of factual challenge, one, on the complaint alone. You can say this complaint could never happen. That I don't think that one will fly. It is plausible. Two, the complaint supplemented by undisputed facts. I think this is the part that they are going to have a hard time with, the alleged victim, as well as Attorney Busby, if they are unable to produce and substantiate the facts that they are alleging. This is where now you're going to have Jay-Z's team say like, okay, well, you went through with these facts. Well, we would like her name. Or if we can't have her name, then you need to substantiate these facts. And then you have prong 3, which is the complaint supplemented by undisputed facts plus the court's resolution of disputed facts. The trial court is free to weigh the evidence and resolve factual disputes. Again, this is 12b1, which is completely different in terms of 12b6, but 12b6 kind of underlines it, which is interesting. So you have to talk about them together in order to satisfy itself that it has the power to hear the case. Because essentially, I would say maybe the backup of what they're doing is they've sued in federal court. People sue in federal court because there are a lot of advantages. The federal court runs a lot better than most state courts. Federal court also has a lot more transparency. To look up all of these filings, these lawsuits, it's very easy. You go on Pacer. I went on Pacer. You create a login. You can see everything. State courts, various state courts will charge you. Various state courts have very out-of-date websites. If you are doing a high-profile case, depending on if you are the petitioner, so the person alleging the harm in the civil court, then you probably want more eyes on it. You would like federal court. If you are the person being accused, you don't want to be in federal court. You'd rather be in state court. It's easier to hide things in state court. New York State Court is run, depending on where you end up in New York State Court, various levels of mess. If you think federal court is slow, state court is even slower. All right. And so basically, essentially, we don't have to go through all the boring legalese. Essentially, what's going to happen now is Attorney Busby and his team, they are going to have to show and prove that they have the burden of proving subject matter jurisdiction. So they're going to have to show this is why this case needs to be brought in the Southern District of New York, which is federal district court here in New York. They are the usual presumption of truthfulness for motion to dismiss does not apply to disputed factual allegations, which is going to work against them. And then 3, the movement, so that's Jay-Z and his team, may submit evidence to rebut factual allegations. So as you see with the letter that Spiro submitted on the 13th, that letter is a summary of the NBC article, basically stating, hey, we are using this as evidence to say we don't agree with the facts. I'm not sure if a judge is going to take one article as fact or if they're going to require them to actually do some PI work, do some digging of their own and say like, okay, if you don't agree with the facts, I need to know the facts from you, not from you borrowing the homework of NBC. We'll see how that plays out. All right, so what's next? What's next is they have requested, and this was filed earlier. I believe this was also filed on the 9th. But they have requested an expedited hearing to be heard on the case because they would like this likely wrapped up before Christmas next week. I don't think that that is going to happen. And then what also might happen, according to Alex Spiro, it is stunning that a lawyer would not only file such a serious complaint without proper vetting. And again, this is why, while I'm not in agreement with Busby and his method of going about sourcing these clients, his method of showing the clients at certain points. When he specifically said and placed the blame on another law firm for the vetting, he opened himself up to this problem. Because now you have the other attorney saying you didn't vet it at all, which is not exactly what Busby said. However, it's not a complete contradiction. It is the gray area, but would make things worse by further peddling this false story in the press. We are asking the court to dismiss this frivolous case today. He asked the court to dismiss it a week before. And we will take up that matter of additional discipline for Mr. Busby and all the lawyers that filed the complaint. So what might happen now is, according to Attorney Busby, which we talked about last week, where he said he's being harassed, his clients are being harassed. We have a board of ethics as a lawyer. You can report a lawyer who has specifically done you harm if they steal your money. What's the example of that man that was on Real Houses of Beverly Hills that stole everybody's money? It's not even an allegation anymore. And now he's pretending that he has dementia. Little blonde man married to the blonde woman. Erica Jane was the wife. What was his name? I forget his name right now, but he basically embezzled all of his clients' monies and essentially then allowed his wife to go on Bravo TV and show all of the Giardi. Thank you, Nicole. I was like, what is that man's name? I forgot about him. Tom Giardi. Thank you. The ethics board, multiple of his clients went to the ethics board in California and were like, hey, before he stole the large sum of money from the plane crash victims, multiple of his clients beforehand went to the ethics board and were like, I think Tom Girardi is stealing my money. Like, I'm missing some payments. Essentially, when you have a lawyer and you receive a large settlement, the money doesn't go to you directly. It goes to the lawyer. They're supposed to hold an escrow, and then they pay you out and they take out their fee. Tom Girardi instead kept all the money and then would little by little give the client some money or say that he didn't have the money. What Spiro is alluding to now is that he is alleging that he might, he said he will do it. I don't know. I think we can take this as a threat. He is threatening through the court of public opinion to Attorney Busby that he is going to file a complaint against Busby. He practices in Texas, so probably in the state of Texas, stating that this is, you could probably do under like malicious prosecution of the law, etc., and that he is going to go after him. This can be taken one of two ways. One, another overzealous attorney advocating for his client to basically say like, hey, this is nonsense. I really believe that you did this because you are a slimy person and you're taking money from me. Or it can be taken the other way of he is threatening someone else's livelihood. So that is likely to play out in the court as well. That, in my opinion, today is Tuesday, December 17th, is not going to play out today. It's not going to play out this week. The court, we could look up the SDNY schedule. The court is out of session. SDNY schedule, holidays. I don't think that they are going to rule on this beforehand. Okay, here's the court holiday schedule. Also, interesting to note, since I've internet SDNY, this schedule doesn't mean this is the judge's personal schedule. The judges do what they want to do. Okay, so they have basic holidays off, but then the clerks are the ones who actually write the opinions. Let me make me small. The clerks, I didn't mean that small. Okay, to here. The clerks are likely out. So Christmas Day, Christmas Eve, they have off next Tuesday, Wednesday. If this doesn't get resolved by the 23rd, this is not going to get resolved until, I would say, between New Year's and MLK Day. That would be my educated guess. Because at this point, the court is going to have to review the NBC article, also what NBC stated, and they're going to have to reach out to NBC since that is being used as evidence that the facts are not in agreement with what Jay-Z and his team are saying. That's going to take some time. And then they're going to have to also issue an order on two things. One, on whether or not the petitioner should be allowed to proceed anonymously. That's the larger issue. The motion to dismiss, I think they threw that in there just to be like, well, just in case, let's throw it in here and maybe we'll win with this. 50-50, we'll see. But the likelihood of the law clerks prioritizing this over their holiday that is coming next week, I don't think so. They don't get paid enough for that, for what it's worth. So we will see. Okay. I literally read it out loud, and that's the problem. Some people don't listen. You didn't mention anywhere near all of the absurd inconsistencies, Stephanie. Tony, I literally read it out loud. Y'all got to listen. Y'all got to listen. Verbatim from NBC, who conducted the interview. Unfortunate. Okay, on that note, let's go through this. And that's everything. So there's the update. There likely will be no update. I will be taking my holiday as well, starting the 24th. So if there's no update by the 23rd, we will not discuss it. I don't think there will be, for what it's worth. So we'll probably talk about this in the new year, and then we'll see if the case is moving forward. Likely the case will be moving forward with the alleged victim giving their identity. All right. This is a very wild comparison. Unfortunate. Okay. It's interesting, the dynamics that are currently going on, because every time now that Jay-Z and his team are saying like, oh, they're just colleagues, they just knew each other, they're just occasionally all the time every year at multiple events together. Then you have Diddy's attorneys coming in and saying, this whole thing is a sham. See, we're all getting thrown under the bus. So Diddy's attorney is still trying to attach Diddy to Jay-Z. Meanwhile, Jay-Z's attorney, Quinn Emanuel, with Spiro, leading that charge, are trying to detach themselves. There's a little bit of cat and mouse going on, which is interesting to see. Interesting to see. All right. Well, on that note, we finished in record time because there was nothing to discuss really besides a civil procedure lesson and what does the court do with inconsistencies. They don't throw out cases. All right. So not just for that, for what it's worth. That's not the legal standard. All right. On that note, I hope you'll have a happy holidays. I don't think we're going to be doing another live stream before the holidays. I doubt it. I'll be here standing corrected if on the 23rd they file something, but I doubt it's happening. So on that note, I hope you'll have a happy holidays. I would say stay warm, but it was 54 degrees today in New York. Yeah, global warming. Unfortunate. So I will catch y'all later. All right. Bye. Have a good night.